In this first presentation on the dangers of no contest clauses, I show that no contest clauses do not prevent contests and rarely result in contestants being disinherited. As pointed out in the introduction, the purpose of a no contest clause is to prevent inheritance contests. The idea is to scare an heir with the threat of disinheritance if the heir even thinks about undermining your will or trust. A typical no contest clause states that your heir or beneficiary will be disinherited, cut off, if the beneficiary dares to contest the validity of your will or trust, or dares to question the meaning of your will or trust, or dares to question the actions of your executor or trustee. In recent years, over 300 court cases have addressed the validity of no contest clauses. That is over 300 contests about no contest clauses. This fact should raise some question in your mind about how effective no contest clauses are in preventing contests. 300 no contest clauses, 300 contests. On the face of it, that is a 100% failure rate. These court cases prove that no contest clauses do not deter contestants from contesting wills and trusts. Let me tell you about just one of those cases. When James Ferber's father died, Mr. Ferber spent 17 years honestly administering his father's complex estate. During this time, Mr. Ferber fought off numerous contestants, all demanding their inheritances and attacking him personally. These years of conflict affected Mr. Ferber so terribly that when he had his own will prepared, quote, he directed his attorney to prepare the strongest possible no contest clause, close quote. Mr. Ferber demanded a no contest clause that, quote, went as far as it could go to avoid any litigation at all involving his estate, close quote. So Mr. Ferber's attorney drafted a no contest clause that was a true work of art. Unfortunately, when Mr. Ferber died, his no contest clause did not prevent a contest. Sandra was a friend of Mr. Ferber and one of his beneficiaries. It seems Sandra was impatient, ungrateful, and manipulative. Sandra filed a contest in court hoping to bypass Mr. Ferber's instructions and take direct and immediate control of the $250,000 Mr. Ferber had set aside for her. After an expensive, drawn-out trial and appeals, costing Mr. Ferber's estate and honest beneficiaries an untold amount of money, Sandra's petition was denied. She would not be allowed to get her $250,000 as quickly as she demanded. But the court also rejected Mr. Ferber's brilliant no contest clause. That is, the court refused to disinherit Sandra. After contesting Mr. Ferber's will and causing so much harm to Mr. Ferber's honest beneficiaries, Sandra was still entitled to her $250,000. When discussing no contest clauses, the first brutal fact of reality is that no contest clauses do not prevent contests. The 300 cases I refer to prove this assertion. You can read these cases for yourself. The cases are cited state by state on my website. Over 300 no contest clauses, over 300 contests. Further, and most importantly, not one of those cases, not one, refers to a study proving that no contest clauses discourage litigation. In addition, my research of numerous articles written about no contest clauses confirms there are no such studies. Believing that no contest clauses must discourage litigation does not make it so. Of course, the fact that no contest clauses do not prevent contests is not the full story. A critical question in these hundreds of cases is whether the contestants were disinherited. That is, do no contest clauses actually work in cutting off contestants? The answer may be surprising. In 80% of the cases involving no contest clauses, Judges systematically ignored or rejected these cheap clauses for a variety of good reasons. In 80% of the cases, the contestants are not disinherited, just as Sandra was not disinherited. In brief, the two brutal facts of reality when it comes to no contest clauses are: one, no contest clauses do not prevent contests. And two, in 80% of the cases involving no contest clauses, the contestants are not disinherited. My name is Craig Hughes. I am a probate litigator. That means I represent in court people who fight dishonest executors, fight cheating trustees, and fight manipulative and hostile beneficiaries. I represent people who fight inheritance abuse and fraud. I am also an estate planning attorney. More about my background, education, and experience are found on the website estatesurpriseplanning.com. In addition, the website contains in-depth information about how to prevent abuse and fraud and effectively contain inheritance conflicts. The first step is to reject cheap solutions and retain a competent estate planning attorney in your local area who really understands probate litigation and the systematic failure and dangers of no contest clauses.